What I will do now is move on to the second judgment, which I think is potentially interesting for you. It relates to vaccinations. It's obviously a very hot topic at the moment when we put the news on, and I suspect it's going to remain quite vogue for some time. So our presiding judge, Mr. Justice MacDonald, continues with his outpouring of judgments on Bailey. This is one of his decisions handed down in December last year, M versus H, and it's at page 65 of your handout. In short, the facts very briefly, 2 children, an application made by the father for a specific issue, in a specific issue order. Originally, the application was confined to the children receiving the MMR vaccination. It then got widened to include all vaccines on the NHS schedule, and any that may be required for future international travel. And then I think for good measure, the father threw in and any COVID vaccine that may become relevant in the fullness of time. Mr. Justice MacDonald decided that in terms of the NHS vaccine schedule, that should find its way into an order. So he gave express approval for the children to receive those vaccines. He refrained from giving any decision on the COVID vaccine, because at that stage it was speculative as to what was going to be the intention by the government and the relevant health authorities and bodies relating to COVID vaccines for children. But this may be something now where you have clients coming in and talking to you about it, because it clearly is now gaining some traction in terms of what may be coming out of government. So what I suggest, if this is something that you need to consider, the authority at paragraph 4, Mr. Justice MacDonald says, and I'll read it, as I make clear at the conclusion of this judgment, having regard to the principles that I reiterate below, it is very difficult to foresee a situation in which a vaccination against COVID-19 approved for use in children would not be endorsed by the court as being in a child's best interests, absent peer-reviewed research evidence indicating significant concern for the safety of one or more of the COVID-19 vaccines, or a well-evidenced contraindication specific to that subject child. And he goes on to say at the end of that paragraph, I'm satisfied it would be premature to determine the dispute that has arisen in this case regarding that vaccine. Later on in the body of the judgment, he does talk about the point relating to having peer-reviewed research that would establish a contrary argument to the vaccine programme. And if in the future we find ourselves in that territory, then he makes it clear that there would have to be a Part 25 application where the requisite experts are brought on board. But my reading of this judgment is that that is something the court won't be encouraging, because then running through the judgment, he traverses and peppers into the judgment regular sound bites of, in the absence of peer-reviewed studies, these courts are likely to support any programme that is rolled out by the NHS for children to receive the COVID vaccine. And he summarises that perfectly in his closing paragraph at 52 of his judgment, again saying, while strictly obiter make it very difficult now to foresee a case in which a vaccination approved for use in children including vaccinations against the coronavirus that causes COVID-19, would not be endorsed by the court as being in a child's best interests, absent a credible development in medical science or peer-reviewed research. So I think that's definitely one to watch out for. Of course, that is a different issue to the Gillick competence point that is also playing out, and the potential dispute that may arise between parents exercising their parental responsibility and children that fall, between the ages of 12 to 15, potentially wanting to do something different to what their parents consider to be in their best interests. But as I say, I think that's a whole different topic, and one which at this stage I'm going to stay clear of.